I'm Ryan Ship from the law office of Ryan S. Ship PLC, located in Lantana, Florida. And today I'm here to talk to you about Florida landlord-tenant law. A notice of non-renewal in Florida is a document drafted by a landlord or by a tenant giving the other party sufficient notice that the current lease agreement will not be renewed for another term. It is important to look at your Florida lease agreement to see how much notice must be given to the tenant by a landlord if the landlord chooses not to renew the lease for another term, or to the landlord by a tenant if the tenant chooses not to renew the lease for another term. Pursuant to Florida statutes 83.575, the lease agreement may not require more than 60 days notice from either the tenant or landlord regarding the notice of non-renewal. Additionally, the lease may provide that if a tenant fails to give the required notice before vacating, the tenant may be liable for liquidated damages if the landlord provides written notice to the tenant, specifying the tenant's obligations under the notification provisions of the lease. If the tenant remains on the property without the permission of the landlord after the lease has ended and fails to give notice, the tenant is liable for an additional 1 month's rent. The notice of non-renewal in Florida needs to be strictly adhered to. I'm Ryan Ship from the law office of Ryan S. Ship PLC. Give us a call today, 561-699-0399.